A Wisconsin courtroom turned tense as 44-year-old Alan Bowell appeared before the judge to face serious criminal charges stemming from a violent alcohol-fueled incident. Bowell pleaded guilty to felony strangulation and misdemeanor battery after prosecutors described a disturbing night that left a woman emotionally devastated. According to the state, Bowell had become extremely intoxicated while staying at the victim's home. What started as a night of drinking quickly spiraled into violence. The prosecutor explained that Bowell became so intoxicated he reportedly didn't even realize he was inside another person's house. Officers responding to the scene struggled to communicate with him, describing how he could barely walk or understand what was happening. But despite his level of intoxication, prosecutors made it clear alcohol was not an excuse. The victim, according to the state, suffered severe emotional trauma after the attack, so severe that she could not even bring herself to appear in court for sentencing. Prosecutors said the emotional impact from the assault continued long after the physical injuries healed. Bowell's defense attorney argued this behavior was completely out of character. He pointed out that Bowell had no significant criminal history, maintained steady employment as a construction field superintendent, and had accepted full responsibility for what happened. The defense also argued that alcohol combined with medication created a dangerous reaction that night. Still, Bowell admitted in court that he was ashamed of his actions and apologized to both the victim and law enforcement. The judge listened carefully before delivering a stern warning. She reminded Bowell that although he was being given a second chance through a deferred judgment of conviction, one violation could destroy his future forever. If he failed to stay sober, complete treatment, or follow court orders, the felony conviction could immediately be entered against him. That would mean losing his right to own firearms, becoming a convicted felon, and potentially facing prison time. The judge also ordered Bowell to complete restorative justice coaching and write an apology letter to the victim, even if she chooses never to read it. In one of the hearing's most powerful moments, the judge spoke directly about alcohol abuse and personal responsibility. She warned Bowell not to walk the gray line with sobriety, saying even one drink could lead him right back into court. Ultimately, the judge sentenced him to 10 days in jail, strict sobriety conditions, treatment requirements, and continued supervision for the next year. What could have ended with a prison sentence instead became one final opportunity for redemption, but with the clear message that the next mistake could cost him everything.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on both of those documents on the first page. Did he thoroughly go over those rights with you?
Yes.
And do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand? So you understand those rights, but do you need me to go over those rights with you in any more detail?
No.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Now, do you understand that if the court does accept the deferred judgment of conviction, the next requirements will not go into effect, and they won't go into effect unless the court enters judgment either through this deferred judgment of conviction or today. So do you understand that you're charged with a felony, and if judgment is entered, you would no longer be able to possess or own a firearm?
Yes.
You would no longer be able to vote in any election until your civil rights are restored.
Yes.
Now, here, the state would have to prove for count 1, strangulation and suffocation, on or around November 23rd, 2025, in Burnett County, Wisconsin, you intentionally impeded the normal breathing by applying pressure on the throat or neck of another person. Do you understand what the state would have to prove?
Yes.
Do you understand for that Class H felony that upon conviction, you could face a fine of up to $10,000 or imprisonment of up to 6 years or both?
Yes.
As to count 2, misdemeanor battery, the state would have to prove the same date, the same time, the same place. You caused bodily harm to NS by an act done with intent to cause bodily harm to that person without that person's consent. Do you understand what the state would have to prove?
Yes.
Do you understand that the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Now, your attorney placed the agreement reached with the state on the record. Do you understand that agreement as it's been reached?
Yes.
Do you understand that I'm not bound to follow that agreement? That means I could sentence you all the way up to the maximum possible penalties for both of these crimes, and I'm not required to accept a deferred judgment of conviction. Do you understand that?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes.
Did you go over that criminal complaint with your attorney, and in particular, a section called the probable cause section, where it basically says what happened that day and why you were charged with these crimes?
Yes.
For the most part, and I do understand that alcohol was an issue or involved here, but for the most part, are you admitting that the facts are accurate?
Yes.
Mr. Becker, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, as well as the preliminary hearing that was conducted.
Thank you. Are you pleading guilty to these crimes, Mr. Belial, because you are guilty of these crimes?
Yes.
All right. Now, has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he looked at the discovery and the evidence and discussed it with you?
Yes.
Have you discussed the facts that you know to exist with your attorney?
Yes.
Has he discussed with you a potential for any legal defenses or a lack of defenses?
Yes.
Have you discussed with him, again, any defenses that you believe could exist?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
Then as to count 1, strangulation, suffocation, a class H felony, how do you wish to plead?
Guilty.
As to count 2, misdemeanor battery, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of both of those counts. The remaining counts and any open matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered as to count 2. As to count 1, the court will allow parties to be heard. Mr. Schmidt, we are in victims' rights compliance, no victim impact statement to be made here today. So argument and sentencing recommendation.
Judge, Alan Belial is a 44-year-old man with no prior criminal convictions. The only criminal history he has is in 2008 and 2010. He had DCs in Burnett. One was not violent. The other seemed to be a reciprocal event with a significant other, where reading the criminal complaint seems the other person initiated it. In this case, this happened many years later. In these circumstances, you can see the level of intoxication of Mr. Belial on the body cam. He was in a woman's room on her bed, and the officers took a great deal of time to even convince him he wasn't in his room in his house. That's the level of intoxication. He couldn't really stand or walk. It was troublesome getting him down the stairs at all. In Wisconsin, thankfully, we're a state where intoxication can't be a defense to criminal culpability, but it's incredibly relevant when figuring out the sentence, how to prevent it in the future, how to protect the public, how to make sure it doesn't happen again. That is why I've structured this as it is. The DJOC has the AODA requirement. That's 100% what's needed in this case. I think there's no doubt about it. This isn't a domestic incident. The victim doesn't even really know Mr. Belial that well. She was just giving a friend of a friend a place to stay when he was clearly extremely intoxicated. There was no inciting incident. Essentially, he was there sleeping. He was so intoxicated, he got up, started hitting the wall. She told him to stop. He stopped once, did it again, came back. That's when he choked her. That's when he attacked her. The reason why we're still getting the conviction and doing the 10 days jail on this is because the way this impacted the victim is so severe. It's just necessary in this case. It's necessary that this be the first conviction for Mr. Belial. It's necessary there's some incarceration. The reason she's not here today isn't because she doesn't care about the outcome of this case or didn't impact her enough to give a statement. It's because it impacted her so much. She I won't go into the details, but she's affected emotionally and psychologically a great deal and still is to this day. That's what I'll leave it to on that. So I think that this accomplishes all the purposes of sentencing. I think that this accomplishes punishment with the jail sentence and not depreciating the seriousness of that with the jail sentence in conjunction with the conviction, the first conviction he has. So going forward, somebody asks if you ever been convicted of the crime. The answer is now yes. And then also the DGOC making sure that we accomplish the rehabilitation and public protection objectives by making sure this doesn't happen again. It was obviously caused by alcohol. He had no motive to attack her at all. So I'd ask the court to follow this agreement. Thank you.
Is that why restitution is, one reason why restitution is being held open? Is she seeking any kind of trauma services?
No, the restitution is immediately after this. She was affected so much emotionally, she couldn't go to work for the week afterwards.
And that was around Thanksgiving, if I'm recalling.
Yep.
correctly.
So she gave us the time card, which shows the time they did pay, but we need the work schedule to show she was actually scheduled to work there. So I didn't realize that until Mr. Becker emailed me, and it was too late to get that from her today.
How, in the state's view, will Mr. Becker have the oversight to control his alcohol intake with the DGOC?
Mr. Belial.
Oh, sorry. I'm sorry,
You're
Mr. Becker.
Totally good. Just wanted to
BBs.
make that clear.
No, I'm
100%.
totally okay with your alcohol intoxication, but Mr. Belial, I'm sorry. With the deferred judgment of conviction, what oversight is there going to be to ensure that he is not only getting that AODA assessment, but that he's controlling his level of intoxication?
Well, the AODA assessment, there's benchmarks in the DGOC by when he has to do the assessment and do the treatment, provide proof to us. So if he doesn't do that, I mean, it's on him to prove that to us. So that would trigger a filing of a motion to revoke the deferred judgment conviction. If you're asking if there's any testing built into it, there isn't anything like that, no.
All right. And is there absolute sobriety in the deferred judgment?
I believe it's a condition of bond. So I didn't put it as that.
All right. I'm gonna pull up bond. There is an absolute sobriety condition. There would have been in that he would still be under bond for a period of 12 months. So, all right. Mr. Becker.
Thank you, Your Honor. I agree largely with the context and the things that DA Schmidt has said. Mr. Belial is 44 years old. He
A
works for
Wisconsin
Zeman
courtroom
Construction
turned
as a
tense
field
as
superintendent.
44-year-old
So he's
Alan
employed
Bowell appeared
full-time,
before the
gainfully.
judge to face serious criminal
He
charges stemming
supervises
from a violent
construction
alcohol-fueled
projects,
incident. Bowell pleaded
loose
guilty to
term,
felony
in the Twin
strangulation
Cities metro
and
area
misdemeanor
predominantly,
battery
but
after
it
prosecutors
spans on this side
described
of
a
the river
disturbing
sometimes
night
too.
that left the woman emotionally
As DA Schmidt
devastated.
indicated, he has
According
no
to the
prior
state,
criminal record.
Bowell had
There are
become
the two
extremely
things that are quite
intoxicated
dated,
while staying at the
08
victim's
and
home.
2010,
What
which
started
didn't
as a
result in
night
any
of
criminal
drinking quickly
convictions.
spiraled into violence. The prosecutor
The
explained
incident here
that
is
Bowell
outlined in the
became
complaint
so
as reflected in the
intoxicated
body
he
cam. There's no
reportedly
question that
didn't even
alcohol
realize he
was
was
at play.
inside another
In
person's
addition
house.
to that, Mr.
Officers
Belial
responding
was
to the
taking the
scene
medication in a
struggled
new
to communicate
dosage,
with
and so
him,
there was a mixture that
describing
he
how he
hadn't
could barely
experienced
walk
before.
or understand what was
Medication,
happening.
there was nothing
But
listed
despite
on
his
the
level of
questionnaire.
intoxication,
At the time, not
prosecutors
now.
made it
He's
He's
clear
not taking it now. No.
alcohol was not an
And
excuse.
so,
The
and
victim,
it wasn't for a
according to the
mental health
state,
issue or anything like
suffered
that.
severe emotional trauma
But
after the
I believe
attack,
because of the
so
dosage
severe
and the
that
amount
she
of
could
alcohol that
not
was
even
present,
bring
there was
herself
an
to
interaction
appear
which
in
he hadn't
court for
experienced
sentencing.
before. As a threshold
Prosecutors
issue, the
said the
amount of alcohol
emotional
present was
impact
high
from
in
the
and of
assault
itself,
continued
right?
long after the
And
physical
so,
injuries healed.
obviously not an
Bowell's
excuse
defense
by any
attorney
means,
argued
just
this behavior
factually
was
what happened
completely
here.
out of character.
The facts as
He
they
pointed
exist,
out
which
that
led to
Bowell
what
had no
happened.
significant criminal history, maintained steady
agreement
employment as a
That's been
construction
structured,
field
the agreement that he's
superintendent,
accepted,
and had accepted
has
full
him taking responsibility
for
for
what
his
happened.
actions that night
The
at the most
defense
severe
also
charge
argued
that he's
that
charged
alcohol
with,
combined with
and at the second
medication
most severe
created a
charge that he's
dangerous
charged
reaction
with.
that night.
Um,
Still,
I think it is
Bowell
a
admitted in
measured
court that he was
agreement in
ashamed of
terms
his
of
actions
what
and
is
apologized to
required of
both the
him.
victim and law enforcement.
You know,
The
I
judge listened
have
carefully
always
before delivering a
described
stern
DGOCs
warning.
as probation
She
light to
reminded
people.
Bowell that
It's the
although he
same
was being
thing. You
given a
have
second
conditions you have
chance
to
through a
follow. If you
deferred
don't follow them,
judgment
you
of
get in
conviction,
trouble. That's
One
what happens on
violation could
probation.
destroy his
The
future
difference here is you're
forever.
betting on
If
yourself.
he failed
You
to
have
stay
something at
sober,
stake, and
complete
that is
treatment,
not
or
being a
follow
convicted
court
felon,
orders, the
which
felony conviction
is
could
a high
immediately
benchmark
be
for
entered
somebody who
against
today,
him.
as he sits
That
here,
would mean
is
losing
getting
his
his
right
very
to own
first criminal
firearms,
conviction on a
becoming a
misdemeanor
convicted
battery.
felon, and
And
potentially
so
facing
Mr.
prison
Belisle
time.
is
The
betting on
judge
himself
also
to be
ordered Bowell
successful,
to
to do what
complete
he needs to
restorative
do
justice coaching
in
and
order
write an
to
apology letter
demonstrate
to the
to
victim,
the DA's office
even
and to
if
this
she
court
chooses
that he
never
is
to
a
read
quote
it.
unquote healthy
In
and
one of the
productive member of
hearing's
society.
most powerful
And that what
moments,
was
the
outlined
judge
in this
spoke
complaint
directly
as of
about
happening
alcohol
November
abuse
23rd,
and personal
2025 is
responsibility.
not his
She
normal,
warned Bowell
nor
not to walk the gray
nowhere
line
near
with
his normal.
sobriety, saying
It's an
even one
anomaly,
drink could lead him right back into
a big
court.
one at that, a severe
Ultimately,
one at
the
that. No
judge
one
sentenced him
discredits
to
that.
10
No
days in
one
jail,
argues that.
strict sobriety
I think
conditions,
pairing the
treatment
DGOC
requirements,
with
and
10 days
continued
jail
supervision for the
is
next
the
year.
carrot and the stick.
What could have
right?
ended with a prison
Case
sentence
law tells us
instead
that
became
probation
one
is the
final
first thing that you
opportunity
look
for
at.
redemption,
That's why I
but with
referenced
the
the
clear
DGOC being
message that the
probation
next
light.
mistake could
We
cost him
can call
everything.
that good right there on the DGOC. And then we're looking the next step further on the jail, right? It demonstrates to Mr. Belisle what happens if you're not successful. Because if he's not successful on the DGOC, he's likely, the state will do what the state needs to do. He comes back in front of this court for a sentencing hearing where anything is fair game, probation, jail, or prison. It's all there. And as a former ADA, now defense attorney, I've seen many of those. And we can all agree that probation is a tough sell on the revocation of a DJOC. It's not impossible, but it's a tougher sell. So